Good morning, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officials, listener learners. I welcome all respected doctors and directors. I welcome all honorable ministers and managers. I welcome all honorable advocates, retired administrative advisors. I welcome the most honorable present Prime Minister Modi ji. Dr. Rakesh from USA, heartily cordially welcome. It is really nice time, nice place, nice session today that we are describing our holy Indian Constitution in the form of Indian diversity, international customs. International customs have been regarded as one of the prominent sources of international law. For a long time, it is the oldest and the original source of international as well as of law in general. It is only in the modern period that the importance of customs has suffered a setback. However, even today it is regarded as one of the important sources of international law. Customary rules of international law are the rules which have been developed in a long process of historical development. Article 38B of the Statute of International Court of Justice recognizes international custom as evidence of general practice accepted as law as one of the sources of international law. In order to understand the meaning of custom, it is necessary to know the meaning of the word usage. The words custom and usage are often used as synonyms. In fact, there is difference between the usage and custom, and they are not synonyms. Usage is in fact the early stage of custom. By usage, we mean those habits which are often repeated by states, as pointed out by Stark. Where a custom begins, usage ends. Usage is an international habit which has yet not received the force of law. In the words of Stark, usage represents the twilight stage of custom. Custom begins where usage ends. Usage is an international habit of action that has yet not received full legal attestation. Usages may be inconsistent and opposed to each other, but this can never be the case with a custom. When states in their international relations start behaving in a particular way in certain circumstances, it is expected that in the similar circumstances they will behave in the same way. This is called the usage, but when this usage receives the general acceptance of recognition by the states in their relation with each other, there develops a conception that such a habit of behavior has become right as well as obligation of the states, and in this way usage becomes a custom. As aptly remarked by Weiner, a custom in the international in the enactment of law, in such usage as that obtain the force of law. It is necessary that the usage should always precede a custom. It is also not necessary that a usage must always become a custom. In certain cases, a usage may become a custom. In certain other cases, it may not become. In this connection, Torsten Gill has summarized the conclusions in the following words. In certain cases, usage gives rise to international customary law. In other cases, it does not. But there is no rule of international law, or indeed any rule at all, which determines when usage will give rise to custom. Together with usage as purely actual phenomena, there are a number of other purely factual phenomena, state interest, power, factors, general opinion, historical events, etc., which in various combinations contribute to the creation of international custom. And custom can arise even without any usage. The coming into existence of a customary rule is an historical process which, in certain cases at least, can be demonstrated by purely historical methods, but there is no rule of law which determines when these factors shall give rise to international custom. When a usage is combined with opinion juris, side necessities, a rule of customary law exists, and it is probably justifiable to say that a usage reflects a customary rule if it is connected with a practically universal opinion juris. Thus, when a general usage in international sphere or state practice is connected with opinion juris at necessities, international customary law exists. This is a statement about a fact, and as such almost a truism sense, since the usage of this kind is general practice accepted as law by definition, a custom, and pointed out by the International Court of Justice in North Sea continental shelf cases. For a state practice to constitute opinion juris, not only must the acts concerned amount to a settled practice, but they must also be such or be carried in such a way as to be the evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. The need for such a belief, that is, the existence of subjective element, is implicit in the very notion of the opinion juris. Sine necessities. The states concerned must therefore feel that they are conforming to what amounts to a legal obligation. For reducing this subjective element, bilateral or multilateral treaties, resolutions of General Assembly of the UN, international conferences and statements of state representative, etc. may be seen. Generation by treaty of customary rules of international law. A provision of a treaty may also generate a rule of customary international law in North Sea, continental shelf case, the International Court of Justice observed that provisions in treaty can generate customary law and may be, in the words of the court, of a norm creating character in the view of the word court. The norm creating process is a perfectly possible one and does from time to time occur. It constitutes indeed one of the recognized methods by which new rules of customary international law may be formed. According to the court, the first three articles of the Geneva Convention on the Continental Shelf 1958 are of non-creating character, but a treaty provision can generate customary international law only when the provision concerned is of a fundamentally non-creating character, such as could be regarded as forming the basis of a general rule of law. In the present case, the court was construing Article 6 of the Convention, which lays down equidistance principle for demarcation of continental shelf between two coastal states. According to the court, Article 6 was not intended to be a norm-creating factor. One of the reasons given by the court was that the principle of equidistance was prefaced by the words, in the absence of agreement, as pointed out by writer, the word court's decision in the North Sea continental shelf cases is a major contribution to that branch of the theory of customary international law dealing with non-creation by means of a treaty. The court articulated a new methodology for determining which provisions in treaties can form the basis of universally binding customary law. As the spreading network of international convention becomes more fine matched, the substantive rules of international customary law may be expected to conform more and more closely to the provision in these conventions. The World Court had implicitly recognized this process in many prior opinions, but it was not until continental self-decision that the link between treaty and custom was forced with precision. The court thus recognizes the fact that the conclusion of a treaty is a step of international significance taken by two or more states that would normally have constituted a component of customary law. Not only is there a definite meeting of the minds in a treaty as we infer from an act involving two or more states that constitutes practice for the purpose of customary law, but also there is the clear articulation of a rule of law that gives the treaty a special impetus towards formulating a general rule. A great many rules of customary international law, perhaps even the majority, and had their origin in treaties, and the world court itself in several cases has used treaties for evidence of rules of law and binding upon non-parties. Ingredients or elements of custom. Following are the main ingredients of an international custom. One is long duration. Long duration is generally said to be an essential ingredient of a custom. This is particularly true of a custom in municipal law. In municipal law, a custom is required to be ancient and immemorial, but this is not necessary for an international custom. Article 38 of the Statute of the International Court of Justice directs the World Court to apply international custom as evidence of a general practice accepted as law. Emphasis is not given on a practice being repeated for a long duration. What is more important is the practice of states accepting the practice concerned as law. In the field of international law, customs have emerged in a short duration. For example, customs relating to sovereignty over airspace and the continental shelf, uniformity and consistency. The custom should also be uniform and consistent. In the Ashland case, the International Court of Justice observed that the rule involved should be in accordance with a constant and uniform usage practiced by the states in question, and that this usage is the expression of a right appertaining to the state granting Islam and duty incumbent on the territorial state. This follows from Article 38 of the Statute of the Court, which refers to international custom as evidence of a general practice accepted as law. According to Manley O. Hudson, the elements necessary are concordant and recurring action of numerous states in the domain of international relations. The conception of each case that such action was enjoined by law and the pleasure of other states to challenge that conception at the time. It may, however, be noted that complete uniformity is not necessary. Nevertheless, there must be substantial uniformity. In its judgment of 27 June 1986 in the case concerning military and paramilitary activities in and against Nicaragua, while referring occasional violations of the principles of non-intervention, the International Court of Justice observed it is not to be expected that in the practice of states, the application of the rules in question should have been perfect in the sense that states should have refrained with complete consistency from the use of force or from intervention in each other's internal affairs. The court does not consider that. For a rule to be, for a rule to be established as customary, as corresponding practice must be in absolutely rigorous conformity with the rule. In order to reduce the existence of customary rules, the court deems it sufficient that the conduct of states should be the conduct of states should in general be consistent with such rules, and that instances of state conduct inconsistent with a given rule should generally have been treated as breaches of that rule, not as indication of the recognition of a new rule. Generality of practice, although universality of practice is not necessary, the practice should have been generally observed or repeated by numerous states. Opinion juries and necessities according to Article 38 of the Statutes of the International Court of Justice. International custom should be the evidence of general practice accepted as law in the view of Bradley in applying the forms of evidence. In order to establish the existence of an international custom, what is sought for is general recognition among states of a certain practice obligatory in the North Sea continental shelf cases the world observed, although the passage of only a short period. A short period of time is not necessarily one of itself a bar to the formation of a new rule of customary international law on the basis of what was originally a purely conventional rule and indispensable requirement would be that within the period in question, short though it might be, state practice, including that of states whose interests are specially affected, should have been both extensive and virtually uniform in the sense of the provision involved and should moreover have occurred in such a way as to show a general recognition that a rule of law or legal obligation is involved. Thus, customary practice, even when it is general and consistent, is not customary law useless, is not customary law unless opinio juris is present. That is to say, unless the practice is recognized as being required by international law. It is this sense of legal obligation, and distinguished from motives of fairness, convenience, or morality, that underlies customary law. Customary rules of international law have developed as a result of one is diplomatic relations between states, two is practice of international organs, three is state laws, decisions of state courts and state military or administrative practices, and four is treaties between states. It is an important matter to see as to how international custom will be applied in international law. There are two leading cases on the point. One is West Rand Central Gold Mining Company Private Limited versus R23. In this case, a test regarding the general recognition of custom was laid down. The court ruled that for a valid international custom, it is necessary that it should be proved by satisfactory evidence that the custom is of such nature that it has received general consent of the states and no civilized state shall oppose it. In case concerning military and paramilitary activity in and against Nicaragua, the World Court observed. In a state acts in a way prima facie incompatible with a recognized rule, but defends its conduct by appealing to exception or justifications contained within the rule itself, then whether or not the state's conduct is in fact justifiable on that basis. The significance of that attitude is to confirm rather than to weaken the rule. Right of passage over Indian territory case Portugal versus India. In this case, the International Court of Justice pointed out that when in regard of to any matter or practice, two states follow it repeatedly for a long time, it becomes a binding customary rule. The facts of this case are as follows. This case deals with the question relating to the right of Portugal to sell its nationals and military through the Indian territory. In- Until 1954, Portugal possessed the right of passage through Indian territory, which was in between Dadra and Nagar Haveli and Daman. The right was, however, subject to control and regulation by India. In between October 1953 and July 1954, certain incidents took place. The relation between India and Portugal worsened, and Portugal claimed that India was exercising excessive control. In July 1954, the people of Dadra, which was a Portuguese colony, revolted against the Portuguese government. It naturally had certain repercussions over the border areas of Indian territory. Consequently, the government of India suspended the right of Indian territory. Consequently, the government of India suspended the right of passage of Portugal over this area. India contended that it had become necessary due to the special circumstances that had arisen. Portugal took this matter to the International Court of Justice. The International Court of Justice had to decide whether India was entitled to exercise control over the way and whether Portugal should send its military or armed forces to the passage. The court had also to give its verdict on the point whether India acted contrary to its obligation. It may be noted that the claim of Portugal was based on the Treaty of 1779. The International Court of Justice decided that Portugal was not entitled to send its armed forces to the law, to the way which fell within the Indian territory. The court ruled that India did not act contrary to its obligation. The court, however, ruled that the Treaty of 1779 was a valid treaty and Portugal was entitled to get passage through Indian territory in consequence of the provisions of the said treaty. The decision is important insofar as that the International Court of Justice ruled that if under a treaty a state gets right of passage through the territory of another state and if it continues for a long time, then it gains the force of law and thereby imposes the obligation upon the state affected to continue to give right of such passage. It may be noted here that on 31st December 1974, a treaty was signed between India and Portugal, wherein the latter recognized the full sovereignty of India over Goa, Daman and Diu, Dadra and Nagar Haveli, as pointed out by Brownie, as pointed out by Brownie, this case raised an issue of bilateral relations, the existence of a local custom in favor of Portugal in respect of territorial enclaves inland from the port of Daman, Damau. In this type of case, the general law is to be varied and the proponent of the special right has to give affirmative proof of a sense of obligation on the part of the territorial sovereign. Opinion juris is here not to be presumed on the basis of continuous practice and the notion of opinion juris merges into the principles of acquisition. So it may further be noted that in Ashram case 1950, also the International Court of Justice held that where a local or regional custom is established in such a manner, it has become binding on the other party. Situation when same principle is found in customary law and is also codified in a treaty. This was one of the matters and area considered by the International Court of Justice in the military and paramilitary activities in and against Nicaragua. In this case, the court was considering the question whether United States reservation with acceptance of court's jurisdiction effectively excluded disputes relating to certain multilateral treaties. Its claims were also based on rules of customary international law incorporated in those treaties. In the instant case, the court found that this identity of content in treaty law and in customary law did not exist in the case of the rule involved. While clarifying the position of law, the word court observed, even if the customary norm and treaty norm were to have exactly the same content, this would not be a reason for the court to hold that the incorporation of the customary norm into treaty law must deprive the customary norm of its applicability as distinct from that of treaty norm. Furthermore, generally, there are no grounds for holding that when customary international law is comprised of rules identical to those of treaty law, the latter supervises the former, so that the customary international law has no further existence of its own. Importance of custom as a source of international law and evaluation. There has there has been a marked decline in the importance of custom as a source of international law in modern times. This is mainly due to the fact that the process of the development of a new custom is very slow. However, in modern times also the development of new custom is possible, and at times customs have developed with accelerated speed. Principles leading to sovereignty over airspace and continental shelf are its glaring example. But in view of the accelerated speed of the changes in international community, custom has now become an inadequate means for bringing about the changes and development of international law. Thus, the development of a custom is very slow, and as compared to it, rapid changes can be effected through treaties and conventions so as to adopt international law in accordance with the changing times and circumstances. The four Geneva Convention on the Law of the Sea 1958 and now the UN Convention on Law of the Sea 1982, to quote only a few examples, bear testimony to this fact. The Soviet Union regards custom as an inadequate means for the development of international law. In one of his articles, Duncan had expressed the view that the development of custom also is based on the agreement between states. Consequently, customary rules are binding only on those states who have given their consent for them. According to the Soviet view, therefore, agreement between states is the only adequate means for the development of international law. In Southwest Africa case, Judge Tanaka observed briefly the method of generation of customary international law is in the stage of formation, transformation from being an individualistic process to being a collectivist process. This phenomena can be said to the adoption of the traditional creative process of international law to the reality of growth of the organized international community. It can be considered from the sociological viewpoint as a transition from a traditional custom making to international legislation by treaty. Thus, in the modern times, the importance of custom as a source of law has greatly reduced with a simultaneous rise in importance of treaties and conventions for the development of international law. But as pointed out by Edward Collins, international organizations also contribute to the development of customary international law by providing a clear, concentrated form for state practice, practically in the General Assembly of the United Nations, where more than 100 states, now 185 member states are represented. The statements and the words of representatives on legal matters provide evidence of existing customary law, as is illustrated by the discussion on and the adoption of the resolution of affirming the principles of the Nuremberg Charter and the judgment. Still, other resolutions amount to an interpretation of the rules and principles which the Charter already contains and which are in consequence binding upon member states authoritative by reason of the standing of the United Nations. General principles of law recognized by civilized states. Para 1C of the Para 1C of Article 38 of the Statute of International Court of Justice lists general principle of law recognized by civilized states as the third source of international law. In the modern period, it has become an important source. It constitutes an important landmark in the history of international law, inasmuch as the state parties to the statute did expressly recognize the existence of third source of international law, independent of custom or treaty. This source helps international law to adopt itself in accordance with the changing times and circumstances, as pointed out by Z. von Lahan, renowned author of international law, who two views are prevalent about the phrase general principle of law recognized by civilized nation. According to one view, the phrase includes such general principles such as both sides of a dispute should be given a fair hearing and no one can sit in judgment in his own case, which are found in domestic jurisprudence and can be applied to international legal questions. The other view regards the phrase as linked to natural law as interpreted during recent centuries in the Western world. According to this view, general principles of law recognized by civilized nations have emerged as a result of transformation of broad universal principles of law applicable to all the mankind into specific rules of international. Our law of nature represents at best a vague and ill-defined source of international law. The former of the first view about the general principles of law is generally prevalent today. By general principles of law recognized by civilized states, we mean those principles which have been recognized by almost all the states. Owing to the gaps in international law, it was felt that the competence of the court could not be confined to making judgments according to positive international law. For example, according to custom and conventions, but on the other hand, it was not designed to give free rein to the lawmaking activity of the court, and the court had to content itself with applying principles of law which could be established as common to the municipal law of all civilized nations and were therefore positive law, positive law, so not positive international law. In the Lotus case, the Permanent Court of International Justice also observed the court considers that the words principles of international law as ordinarily used can only mean international law as it is applied between nations belonging to the community of states. It may be noted here that a principle of law which is recognized by domestic law with a large number of states does not automatically become a principle of international law. It becomes a principle of international law only when it is recognized as such by the world. Judge Latipage. Judge Latipage has therefore rightly remarked that the main function of the general principles of law has been that of a safety valve to be kept in reserve rather than a source of frequent application. The word court resorts to the application of this source only when in a case before it. There is neither an international convention nor a custom in respect of the dispute involved. Thus, Article 38, paragraph 1C of the Statute of the International Court of Justice places on record one of the main sources of the rules of public international law. Indeed, it describes the inexhaustible reservoir of legal principles from which the tribunals can enrich and develop public international law. I would like to thank all my brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, officer, official, listener, learner. I thank all respected doctors and directors. I thank all honorable Mr. and manager. I thank all honorable advocate, advisor, Mr. Advisor. I thank the most honorable president, Mr. Giri. Thank you very much. Have a nice day. Especially all of you. Good morning to all of you. Thank you. Thank you.